Hello and welcome to Barwell Solicitors Let's Talk Law, the podcast where we break down legal topics that matter most to you and your family. I'm Greg Hall, and today I'm joined by our litigation solicitor, Joanna Burke. Welcome, Joanna.
Thank you for having me, Greg.
No problems at all. Now today, Joanna's going to be discussing the Renters' Rights Act of 2025. To start with, Joanna, can you just give us a little breakdown of what that is?
Yeah, so recently the government's obviously, I say recently, probably the last few years, talking about changing the eviction process and the landlord-tenant relationship. And they've finally done it. So they passed the Renters' Rights Act and the main stage is coming into effect on the 1st of May 2026, so fast approaching for this year. And it will go into a lot of new aspects for landlords and both tenants for us to explore.
Okay, what are the main changes?
So firstly, the original AST that everyone uses for their agreements and being able to enter lettings, they're going to be no more.
Right.
So we're now going to go into periodic tenancies. There will be ways of putting into what you expect into a formal document, but you're now going to have more of a rolling periodic based on a month-to-month rental, as they are changing it that you can no longer take more than 1 month's rent at a time upfront in advance. So long gone are the days of someone offering to pay you 6 months in advance to, get that property. And then moving on from that, you're going to be looking at no more no-fault evictions, so our Section 21 notices that everyone seems to really rely upon for certain things of when, you just need the property back to sell or something like that. And the tenant's not really done anything wrong, but that is now going to be abolished, and you're only going to be able to rely on the traditional Section 8 notices. So the other thing on rent is, at the moment, you can change your rent, as many might know, via agreement, having a rent review clause in an act, or the standard Section 13 notice. So our Section 13 notice is now going to be the only method. So you can increase your rent once a year. So anything you do include, so you could say, I want still to keep my rent to review clause in, still want that to be in the information I'm going to provide to my tenant. Things like that will become invalid. So we need to be very careful moving forward that we aren't going to be going into prohibited payment area, because that has been around for a while. So many will know of the sanctions that can potentially come with that already, but I'll avoid that for today. Okay. Potentially we'll talk about that on another podcast, Greg.
The next one.
And so that will be a very big change. The other big change, which actually is more for tenants, is being able to keep pets in the property and being able to request that from your landlord. So not much guidance has been given, but what could potentially happen, Greg, is someone will come along and ask if they could keep something, say chickens or a snake or a dog or a cat more normally. And you're going to have to, if there's a reasonable reason, then absolutely fine. You'll be able to say sorry and provide the reason of why you're not going to give the consents.
The chickens.
The chickens. Yeah. I don't know a lot of people that will have the garden space for chickens, but
True.
That will all come out in case law. So it's going to be very much watch this space to what will be accepted and not by judges moving forward. I think you're going to have a lot of people looking at floor spaces and things like that. But again, we have to watch out.
Right.
And the other thing is, if you have a flat, or as usual, as standard, as many will know, check your superior lease, because if that says you can't have pets, that will be an excuse, because obviously no one wants anyone to be in breach of their own contracts or their own leases. So that will be another thing to watch out for, as people will do anyway for different reasons already. And then moving on, the big change for evictions, the happy conversation of most landlord and tenant relationships, we will solely be on grounds 8. So a big change, because as we know, Section 21 will allow paper determinations. So you put in an application, if it's all right, everything's correct, the judge is going to go, absolutely, here's your possession order, here's the property back, and you're able to do whatever reason it was you wanted it back for. But now you're going to go to grounds based on the Section 8, and that will lead us all to hearings. So every case, you will have a hearing. And I think that's going to affect the courts a lot, so it'll be interesting to see how that goes. Currently, I know a lot, obviously, if there's backlog, depending on where you are, can depend on how long you're going to obviously take you to get your property back.
Right.
But the government have increased the grounds, so they've looked at potential loopholes that need to be addressed. Okay. The main one is if you're going to sell, because that was mainly for what Section 21 was for, I feel. Most people would rely on that because there wasn't anything under Section 8 at the present. So people are going to be relying on a grounds to sell. It's got some, obviously, tick boxes to match. And same with all of them, really. But you're going to be able to sell. You'll also be able to, if yourself or your family wish to move in, there's going to be a ground for that. So if you want to sell the house you're living in to maybe go back to your hometown or be closer to your parents, things like that, you see quite regularly, you would now have this ground to rely on instead of the Section 21. Then there's also additional grounds where you've got, if your superior lease is going to expire, there's those loopholes being closed up. I know we're predominantly focusing on private rentals, but there's going to be change for student lettings, increases for social housing. So there's all sorts in there, but they're the main ones I expect landlords to end up relying upon, other than the usual, which
I understand.
Takes me on nicely to grounds 8, 10 and 11, mainly ground 8, but I know they clump together most times in a nice 3. So ground 8 at present is a ground you rely on for when someone's not paying their rent, and that's never good, no income.
No.
So that's going to change from 2 months worth of rent arrears to 3 months worth of rent arrears.
Okay.
And then they're increasing the notice period. So currently, get your 2 months worth of rent arrears, you then end up going, I'm going to now serve a 2-week notice and hope your tenant vacates or start proceedings. Unfortunately now, it's going to be 3 months and then a notice period of 4 weeks. So you could end up essentially, before you're even getting to proceeding stages, of 4 months in rent arrears. So I think there's going to be a lot of development for landlords to kind of watch out for, and patterns that might occur in which will happen with, courts eviction process delay. But yeah, they're the main changes.
Wow, lots of changes, lots of changes. Now, there has been talk that local authorities have an increased ability to impose sanctions on landlords. Can you tell me a little bit more about that?
Yes, so sanctions are coming into place with increased powers by the local authorities. So local authorities do obviously have some powers currently with fine abilities, prosecution abilities, but they are going to increase so that there's more of an incentive for local authorities to be able to, give out fines and have some benefit from doing so. So what we're looking at is, the main concern for myself and most landlords will be, and managing agents, is that in eviction proceedings, there's going to be a stipulation that on your service of a notice for eviction, that you mustn't do so knowingly or recklessly that you're not going to get the property back. So it's really important that, you make sure you are, I'm going down this route, I know I'm going to get possession, I'm happy with that. Right. Obviously, there's going to be investigations if that's the route they choose, and the route for penalties will be looked at if they decide not to prosecute. Right. So when we look at the potentials that can be enforced against a landlord or their agent, which is very important to consider because that will include solicitors, managing agents and the landlord themselves, is that the first offence of the committal will be up to a £7,000 fine. Whereas if you continue with reckless behaviour or knowingly doing something you shouldn't be doing, then the local authority's power increases to a £40,000 fine.
Right.
And worryingly so, for obviously all involved, that's quite a hefty amount to be paying out if
Absolutely.
you're, just trying to rent and, or get your property back. But now I think you've got the routes, you've got the safer routes. It's just Section 21 was a heavy influence for those sorts of, I don't have a reason back for my property. Now I need to have a reason.
I understand.
Yeah.
So from discussing the notices of eviction, when will the current eviction process cease and the new legislation kick in?
So the new legislation has got a few stages, predominantly focusing on stage 1. So that is going to be mainly the changes of notice and the changes I mentioned earlier. Mm-hmm. So the 1st of May is when the Act comes into effect. So that's a key date there to remember and to think, if I want to rely on a current ground, what do I need to do? So what we would suggest is if you did need a Section 21 or a current ground for any rent arrears or anything, that you'd contact managing agents or something, you'd check that the paperwork is correct and things like that, because what you will want to be doing is serving either of your notices before the 30th of April 2026. Right. And that will include deemed service. So depending on how you're allowed to serve your notice, making sure deemed service will still be on that day. Otherwise, right, send it at least a week before. Right. Give yourself a safety blanket.
Definitely.
But that's definitely the deadline date for notices. Obviously, there's going to be notices currently served, which will have their same shelf life. In a sense, some will be limited. So if you've got a shelf life that nicely matches up, you've got still your 12 or 6 months shelf life or notices currently existing. Whereas if you serve a new one now, you're pushing it on your shelf lives for current, so you would have till the 31st of July 2026. So you wouldn't say if you served it on that April, you wouldn't then have your 6 months or your 12 months to rely upon it. It appears they've instigated it at the government so that from the 31st of July, applications of the old method will cease. Right. And then the final one, which is very important to all landlords or managing agents, is if you've got an existing tenancy, that you're going to want to send a written summary. Mm-hmm. So this is essentially the document to confirm to your existing tenants main terms, anything you potentially, want to have still moving forward, and that there's not really been given much guidance. I'm sure the government will place more stuff out on what that needs to include, but currently it's telling you to get the main key information down, because you're not going to be able to keep, the term, right, if you're taking more than 1 month's rent. So those things will automatically change. But they're saying that must be served by the 31st of May 2026. So they've only given you a month for that one.
Not long.
No, not at all.
So do you have any recommendations on what landlords and managing agents can do to prepare?
Yes, I would definitely get looking at those written summaries for your existing, and also looking at the new style of the written information that's going to be needed to be provided to your tenants, making sure that plan and pack is in place. I would also consider looking at all rentals that they have and whether they need to rely, like I said earlier, on the Section 21 notice or the Section 8 on the current grounds, as it's going to fall away and they're a bit wider and lenient for landlords. So if managing agents and landlords are doing a review on all their properties anyway, that they make sure that their documents are all okay and everything's in place, so that they're on top of all their filing, they can fix anything that they might need to. because if we're relying on this new ground that's going to be very, I feel like, diverse in what's going to come out from the courts, we're not going to know for sure what the rules are until someone takes it all the way for a hearing. That they know if, they need to rely on a ground, they can go to whoever's going to have to issue proceedings. Here are all my documents. This is how much I've kept on top of things. And the main things as well, I'd say, as usual, is keeping up their good practice of good check-in reports, good check-out reports, making notes and keeping any correspondence with their tenants on disrepair, any times they've needed to attend, any information they've had in, because that will all assist any cases moving forward anyway. And if, they're relying solely on rent arrears, they're going to have their running rent schedule anyway. They're going to have demands, letters and things like that. So it's all about just maintaining on top of everything you've got. And this will hopefully as well help that if you're going to assess to move forward with a eviction process, if you're going to reasonably know you're going to get possession at the end and avoid those fines.
Right.
So, yeah.
So there's a lot of changes ahead. Do you expect any more changes to come?
Yes, so there's meant to be 2 more stages, which the government are still obviously haven't put an implementation date in fully, but there's going to be a lot of things put in place, such as a registration for landlords. I believe they're looking for that anyway at 2026, so end of this year. But it is a very much, again, watch this space, because we never know what the government's going to decide to push it out. Are they ready? But that will mean all landlords need to be registered. I believe also managing agents might have to register as well, just as, if they're acting on behalf. So it is going to potentially be a big change, and for something landlords will definitely want to comply with. No one obviously wants to risk any sort of fines or prosecution. And if you can get ahead of the game, why not? And I think there's going to be elements of it as well, allowing you to upload documents. So staying on top of your gas safeties, EPCs, things like that. That will just, if they're all stored and documented safely, it'll make that process nice and easy.
Right.
And then there's going to be a landlord ombudsman. So it'll allow tenants to add in complaints. It unfortunately doesn't work both ways.
Right.
So it will very much be essentially a managing body to keep everything in check. But then, we have those, and so do a lot of other areas. So it's just another way, I think, of helping regulate, and the government not allowing that loophole to continue, of there not being some sort of regulatory body. And then the other big change that the government have always been tampering with is looking at having harsher things in place to make sure a property is obviously up to standard.
Right.
So you've got the Alawab's law, which is obviously tackling serious and hazardous health issues. And that is very important to make sure the property is safe for the person living in there, and that landlords are obviously actioning in a reasonable time anything that could be detrimental to health, safety, so that the properties are of a good standard for tenants to live in, and vice versa. If they, they ever do recover that property, they've been maintaining it, and if they move back in, it's safe for them, better to sell, all sorts of things. But just making sure that those elements of danger, especially in relation to mold and damp, which has become a bigger issue. We're a very wet country. Are just all dealt with and managed properly. So there will be a lot to come. And I'm quite excited to see the change, although it's going to be unknown in a sense.
Absolutely. But thanks again, Jo, for coming today and sharing your insights. It's been really informative. If you are a landlord and you need assistance with eviction proceedings or any landlord-tenant matters, please contact our litigation team. Their contact details are on the screen now. Thank you again for watching. Don't forget to hit the like button and subscribe so you don't miss an episode. Until the next time, goodbye.